Over a decade ago, in the lead up to the Infringements Act 2006, financial counsellors, community solicitors and legal aid lawyers came together to have a common and united voice to change an unfair infringement system which discriminated against marginalised and low-income people. Despite improvements and the prospect of reform, the relevance and importance of the Infringement Working Group has never been greater. The system is still grossly unfair and difficult to navigate. But we do have Julian Burnside to be our keynote speaker. I'd like you to introduce him.
I actually feel rather diffident being here because all of you in this room know much more about this broad area than I do. My involvement in this area is recent and accidental and fairly limited because it's confined to the Mikey system. My exposure to the Mikey system has actually taught me something about the way the infringement system operates, but I won't even pretend to know a tenth of what you know about it. As I say, my involvement in the Mikey aspect was accidental. I was contacted by a bloke at Melbourne University who's got a bee in his bonnet about these things, and he knew someone who had touched on at Mount Waverley, then couldn't get the gates to open at Melbourne Central, went in search of help, and was assisted by an officer who said, "That's okay, I'll just take you through the disabled exit." Went through the disabled exit and handed him over to a group of authorised officers who were standing there ready to fine him. He was told that he could pay $75 on the spot, which he didn't like the idea of, or, they said, it'll be $223 if you're taken to court. Now, he was, I think, a little bit sort of obsessive, so I naturally gravitated to him when I met him, and he decided to stand his ground because he insisted he had touched on. But they had a little reading device which said you didn't touch on. Now, when you think about it logically, there are a couple of possibilities. One is that he was mistaken about touching on. The other is that the machine isn't quite accurate and up to the task, either at that end or at this end. So he decides to make a bit of a fight of it, and that's when I get persuaded to go along and help him. So there's a court date, and I said, well, what we've got to do is write to the department and ask them for the CCTV footage that covers the point where he touched on, plus the service records of the touch-on machine, because it's always a possibility that that machine was not functioning properly. His story was, I couldn't see the screen because there's sun shining in. It's sort of 8:20 in the morning and I've got a crowd of school kids behind me and can't hear a thing. I touched on the way I normally touch on and then I get pinged at the other end. They said, no, you didn't touch on. But then, in response to our letter, they refused to provide the CCTV footage because they said it had already been wiped, and they refused to provide service records for the machine. No reason given. So that seemed to me like a fairly good foundation for a defence, because what's a court going to believe? A guy who says this is what I did, or machines which say something different and where other available evidence is simply not produced. So that's all looking quite good. They did provide one thing, though, which interested me a lot. They provided, sort of automatically, a printout of the transactions on the touch-on machine for the 20 or 30 minutes surrounding the time he said he touched on. And I looked at that, and it's just a list of Mikey numbers, which is sort of like 15 digits or so, and the exact time that that card touched on. And I looked at it, and I saw with interest there are a couple of points where the same card touched on twice at the same time, like the same second. And I thought, well, that's odd. I suppose your hand could shake a little bit. It happened half a dozen times during the 20 minutes covered by this printout. So I thought that was unusual, although plausible. But then, since I'm a bit obsessive and went through all the numbers, I found one little passage where card 1 touches on, card 2 touches on, card 1 touches on again, card 2 touches on again, all at the same time. Now, I can't think of any event in the real world where that is possible. And that suggests that there's a problem with the machine. Now, Rania Spooner, who's a journalist with The Age, who was interested in these matters, contacted the department well after I had contacted them. I'd said, look, this is going to be a fight. Are you going to withdraw? They said, no, we're not going to withdraw. Rania Spooner contacted them a couple of days before the hearing, and 2 hours later they withdrew. So if you want to be effective, be a journalist, not a lawyer. What offends me about this system, and it's far more superficial than what offends you about the way the infringement system broadly works, what offends me about it is that for many people, the idea that you can pay $75 on the spot or $223 if you go to court is actually less expensive than taking a day off work to go to court. Leave aside getting a lawyer, just the fact of taking the day off work may cost you more than the amount they're asking for. And to my assessment, that means it's a standover racket, because that's how standover rackets work. You know, pay us a bit now, pay us more later. The alternatives are much worse for you than paying up. So that offended me, and I found myself embroiled in it. My objective, of course, is not to save every person who's been done badly by the Mikey system, but rather to persuade the government that there's enough pushback that they should start changing the system in ways that make more sense. But all of these things, and I'm sure all of you have got stories like this, all of these activities create bizarre circumstances that really shock you about the way things work. First of all, there was a bloke who contacted me. He'd been fined by Mikey, by the public transport officers, because he was walking across Collins Street. He was just crossing the road at a point where there's one of those huge tram stops, and there's an authorised officer on the tram stop who's writing out a ticket for some bloke who is taken off the tram. This character is walking across Collins Street. The officer stops him and says, "Show us your ticket." He said, "I haven't got a ticket, I haven't been on the tram." He said, "Yes, you have." And he booked him. Just walking across the road. Then when you complain, of course, as you all know, under the infringements legislation, you can ask for a review, and the penalty can be withdrawn if special circumstances are shown. The standard response on reviews in the Mikey system, and presumably in other areas as well, the standard response is, this is an offence of absolute liability, you've got to pay. And at the foot of the form there's a BPay form so you can pay up on the spot. Now, to say it's an offence of absolute liability is not only incorrect as a matter of law, it kind of misses the point, because the process of review and withdrawal assumes that you're guilty of the offence and allows you to be relieved from the consequences of that. But it seems that they don't understand it. And when this is drawn to their attention, it turns out that the review process in any instance takes about 10 seconds. It's not a review that deserves the name. And if any of you have a case that throws up circumstances like that, can I suggest that one available argument is the whole process fails at the threshold because there has not been a statutory review that's worth the name. And if they don't give you the review that the statute requires, well then the steps that follow may be invalid. I got an interesting letter sent to me just a week or so ago. A person had written in asking for a review, and the letter includes this. In relation to your matter, there's no dispute about the fact, and this office would accept your claim that you had a Mikey and you touched on at Sandringham on the date and time you say. But the offence you've received the infringement notice for is failing to produce a valid ticket without delay on request. Not that you didn't have a ticket, merely failing to produce it. And they refuse to withdraw the penalty. Okay? We accept that you touched on, we accept that you had a valid ticket, but you didn't produce it. Therefore, we're going to fine you. That's any bureaucrat who can write a letter like that deserves to be working in a different regime. Now, the $75 thing, I don't know how many, probably most people in the room have struck this. You know, you've got your Mikey card and it turns out it's a concession card. They're not distinguishable. But you've picked up the kid's concession card by mistake and you've used it and you get caught and they offer you $75. Well, $75 on the spot fine seems reasonable. Or you've run out of credit on your Mikey card. You've only got 75 cents in debit because the fare you've paid has taken you into debit. They ask you for $75 on the spot. You ask if you can just top up. They refuse. Did you know the $75 is not a fine? It's a penalty fare. So they can accept a fare of $75, they can't accept a fare of 75 cents. I don't know why a system would be worked in that way. The irresistible conclusion that I've reached on this area is that this is not actually about law enforcement. It's not about making a more peaceful and well-regulated society. It's all about revenue. It is just an easier way of raising revenue than the alternatives that face the government. And no law enforcement mechanism should be used simply as a revenue-raising device. Now, the whole infringement system seems to me to have that characteristic, that it is about raising revenue. And that raises a very important problem, because if this is about revenue, it is probably the most regressive tax imaginable. These things impact the poorest people the hardest. I mean, a bloke whose Jag is off being serviced and who takes the train into work gets a $223 fine. For him, that's no problem at all. But if it's a person who's been unemployed for a long time and is going off to a job interview and they haven't been able to top up their card and they get a $223 fine, that is a massive imposition on that person. And it seems to me that a government which was enlightened would recognise that the way the infringement system works is unfair, disproportionately on people who have the least resources. And if that's thought to be consistent with good regulation of society, well then, frankly, I think they need to reconsider the whole system, because this is going to cause discontent and misery and hardship and all the consequences, all the galaxy of problems that flow whenever a person in difficult circumstances has an unreasonable burden placed on top of everything else. And that reminds me, and I want to finish on this because, as I say, you know more about this system than I do. It reminds me of the best piece of street art I think I've ever seen, and many of you will have seen it. It's by Banksy. It's a full-size drawing painting of a guy sitting on the street in a hoodie with his cap on the pavement and a sign around his neck. But the sign says, "I don't want your coins, I want change." And that's what we should all aim for in this system. Thank you.
Our first panel, we're running a little bit late, so I'm going to be quick and try and keep this on track. So Sam Morgan, sitting closest to me, is the acting manager of the Infringements Court. He has worked through in the Infringements Court for a number of years. Next to Sam is Susan Dobson. She is the Manager, Strategic Policy and Strategy, Infringement Management and Enforcement Services. She's been with IMES since 2009 and has worked closely with the Infringement Group. Joanne Parkin, Financial Counsellor with Uniting Care. She has worked in the community service sector for over 20 years in both the UK and Australia. She has a strong commitment to social justice and has worked with some of the most marginalised groups. Angela Soldani, she has been a judicial registrar. I don't think she's a stranger to most of you, with the Magistrates Court since 2006. Prior to that, she was the sessional member at VCAT and then the Mental Health Review Tribunal for approximately 10 years. On the end is Damien Stock, a senior lawyer with Victoria Legal Aid in the social inclusion team with the Civil Justice Program. He has significant experience in the practice of infringements law. He pursues strategic litigation and contributes to law reform. So, to start, our client John presents in a confused state. John has no paperwork except for public transport fine he received on the way to see you. John cannot remember what fines he has and when he got them, but says he's been getting them for years. Joanne, would you like to start this conversation and tell us a little bit about what it's like working with clientele who are disadvantaged?
This is not an unusual situation where someone would turn up in quite a distressed state. The infringement system, as Julian Burnside has mentioned earlier, is very difficult for people to navigate, and it is unjust in the way that the fares are charged to people who are on very low Centrelink incomes. So quite often people will arrive and either they haven't opened their mail, they have destroyed their mail because they have not been able to find a way to resolve the matters that are before them. That if you're on a New Start income and you get an infringement for $200, $300, $400, you cannot pay that without putting your housing at risk, putting food at risk, putting the bare necessities at risk. So often people are not paying and not dealing with matters because of the complexity. So often people arrive in a state of distress and don't know where to start. So I think we all need to bear in mind that we're here to learn today more about this complex system. The clients that we're seeing every day are disadvantaged, they're stressed, and there are significant negative outcomes that can come from this system if people don't deal with them effectively. So I think it's important for us to bear that in mind when we're seeing the clients on a day-to-day basis.
What Joe was saying is incredibly correct. We see so many clients coming in with plastic bags full of unopened mail, and I think Justice and Regulation have identified that the system doesn't kind of work when you get more than one fine. You just put your head in the sand, and the first thing we need to do is find what fines are out there. So we may all appreciate that fines can come from a range of issuing agencies once they go through infringement notice and penalty reminder notice stage, 28 days each. They are all lodged with the Infringements Court. If you write to the Infringements Court, you can get a list of all outstanding enforcement orders and infringement warrants, stages 3 and 4 of a life of a fine. But it's not going to capture all of those fines that are still in stages 1 and 2 by an issuing agency. It could be an electoral commission for failing to vote, or a hospital, or a council that you've driven through. What we tend to do at Legal Aid is use the online fines portal through Fines Victoria, fines.vic.gov.au. To use that, you need to have the client's surname and driver's licence number, I think, maybe an obligation number as well. And that will print out all of the fines that are either at enforcement order or infringement warrant stage. Then, of course, you'll need to identify what fines are still in the system that haven't made their way to the Infringements Court. And this poses a problem that we'll probably return to, but we often have to deal with, if we're talking about revocation and special circumstances, a couple of applications or a couple of tranches, because you can only revoke fines which are with the Infringements Court. Probably getting a bit ahead of myself at the moment though. So either writing to, and we tend to write or use the online portal and just get all the list from the Infringements Court would be the first step, Gary.
Thanks, Damien. Susan, are we going to see a change in the way that infringements, the life of infringements in the upcoming reforms?
Under the Fines Reform Act, the infringement's life cycle will be shortened, so there will be shortened timeframes from the minimum timeframe by which you have issued an infringement notice. So currently it's 28 days. That will be reduced down to 21 days. Similarly, the life cycle, or the period of time for the issuing of a penalty reminder notice, will be reduced as well, and the deemed served period as well. So we've got deemed served provisions in our legislation which basically outline that a notice will be served within a 14-day period. That's reduced down to a 7-day period. So the whole infringement's life cycle will be truncated, and the rationale behind that is that people need certainty, they need clarity, and to reduce the timeframes will provide efficiencies but also certainty for people. The reduced timeframe for the infringement's life cycle really only refers to the statutory notices provided in the Infringements Act. So that's the infringement notice, the penalty reminder notice, and then the timeframes for lodgement, enforcement order and warrant. It doesn't relate to the tolling notices that happen prior to the issue of an infringement notice.
In terms of visibility, there are some significant issues at the moment, particularly with councils and local government, because you need to go out to the particular agencies to get that data. Fines Online is probably the best resource and the one that I would advocate for using.
Can I just go back one step, Gary, just to make it clear about what the Infringements Act really does in terms of dealing administratively with minor charges, because there are still some issuing agencies out there that elect to use charge and summons and don't elect to use the Infringements Act. They're going to pose a problem for you because they're not going to follow the path that we're talking about, but I think they're largely the exception. In fact, you see very few of them. On the whole, though, we're dealing with an administrative process of recovering small amounts of money and avoiding what is otherwise the criminal justice system. Issuing agents can elect to use this system. Most of them do.
And that's fair. I'd also add that it's appropriate that issuing agencies retain prosecutorial discretion on how they treat their infringement offences or their offences, and they can choose to prosecute in open court or they can choose to use the infringement system.
First of all, I'm going to ask Damien and Joe. Joe, what are special circumstances? How do you prove special circumstances?
I work at a drug and alcohol treatment agency, and that luckily falls within one of the special circumstances stipulated in the Infringement Act. If a person who committed an infringement was at the time experiencing one of the special circumstances, which are a serious addiction to drugs or alcohol, a mental health issue, some sort of acquired cognitive functioning or homelessness that affected their capacity to either understand their behaviour or control their behaviour, then they can make an application for revocation, which means a cancellation of those infringements. And then there's a process that can take a number of months to hopefully have those matters resolved. There are a number of hurdles along the way. It is a long, drawn-out system with complexities, and unfortunately clients often fall through the cracks and disappear during the process. They may fail to come back with the adequate letters to prove those special circumstances. So it's important that we hang in there with clients and support them and encourage them and see that there is actually a resolution to these issues that have been holding them back for so long.
The legal issue, I suppose, is the need for the nexus. You've got to show that because of those symptoms of the illness or their circumstances, they are unable to avoid committing the offence or unable to understand that their conduct was causing the offence. The practical issue is getting someone who's authorised to put into a report that that was so. We see plenty of, and we have as a prerequisite that we think that a client has special circumstances if we're assisting them based on their instructions only. They say, I've had this diagnosis for a number of years and I think it affected me. That's all well and good, but then getting a medical report that will satisfy the infringements court that that is so is what we find takes up 90% of our time. Well, not that much, a lot of our time.
I think we certainly recognise this is a real challenge in that medical practitioners' role typically is to diagnose, and it's not to establish a nexus or to explain the way that a person's condition might affect their conduct, and that's something that quite a lot of GPs and counsellors and people that we get out and speak to have a lot of difficulty comprehending, and some will even argue that it's not their role and therefore they don't do it. For us as well, we have to make an assessment based on the papers before us, so we only get to see the evidence that's presented as part of the application. When they progress through to the special circumstances list and they go before a judicial registrar, they're in a different situation. But in that initial assessment, we're going off the papers, and typically what we find is that the issues that we sort of are engaging with around the lack of a nexus. So the person will say the person definitely had the condition at this particular point in time, and this is the condition, but then there won't be anything to say, and this is how it contributed to them offending.
Its difficulty is often establishing that nexus between the mental illness, the substance abuse or the homelessness to the offending, the ability to control the offending or understanding the offending. And a lot of that is often the way the reports have been prepared, who prepares the reports, the timing of the reports, and whether or not the person is actually there in court. It's easier in many respects when the person actually is there, so you can engage with them themselves and you get a different picture from just the papers. So if it's just the papers, that's the difficulty in getting that nexus established. I know that is sometimes difficult because sometimes we're talking about offences which occurred several years ago, and I appreciate that there may be some difficulty. I would prefer to have reports from treating practitioners who actually have a relationship with the person for whom they're preparing the report. Oftentimes we'll get a person who has seen the author of that report on the one occasion, and a lot of the reports are very, very repetitive, and they tend to lose their effectiveness because they are repetitive, and the same words are used for the same reports for different people, so they tend to lose their effectiveness. But I understand that it may be very difficult to get reports from treating doctors because of the time frame between the offence and the time that the reports are prepared. But treating doctors have a relationship and are able to perhaps give a better picture of what that person was like at the time of the offending. But I do appreciate that it is difficult.
So can we take this opportunity to ask you now, would you prefer something from their treating GP, even if they weren't treating them at the time the offences were incurred, or they can't speak to great detail of the nexus? Would you prefer a report from their GP saying this is as good as I can do, or I'm not prepared to write something before we go and get an independent assessment?
Well, if they're not prepared to write anything, that's going to be a bit difficult, isn't it? But I would prefer a report from someone who knows the patient, the client. I'll leave it at that. But there are some. But there are reports that are prepared by psychologists who've seen the person once or twice, and they see them for the purposes of writing the report. That are excellent, that are very, very good, and there are others that are not quite so good.
So sometimes people don't have very good documentation around what treatment they were getting whilst they were in active addiction or had episodes of mental illness. But their current treating doctor and psychologist, psychiatrist is able to provide a much more updated report. How useful do you find that?
The updated reports are very useful, particularly in the decision of sentencing. What's an appropriate disposition? So what's happening now is important as far as that is concerned. And just to see how the person is going and the likelihood of any reoffending, if their condition is stable, if it's been stable for some time, it makes a difference as to what the sentence would be.
Damien, can you tell me what when is our client eligible for assistance for funding from legal aid?
Speaking about special circumstances only, because we deal with fines in other areas, a client has to have at least $5,000 in outstanding infringements, enforcement orders or warrants, and convince us that they have special circumstances. We won't generally know at the time because they won't have sufficient reports at the time, although that would be ideal. So a likelihood of having special circumstances and $5,000 worth of fines. We open about 90 matters per month, and the first thing we do is get all information of who's assisted them over the time that they've incurred the fines and write to those people asking for reports. If someone's eligible for assistance, then we can pay for those reports on a scale. GPs get paid less than psychologists and psychiatrists, and we can brief a duty lawyer or barrister to appear in the special circs list.
The other two areas, apart from the three criteria for special circumstances, the other two areas where we're increasingly having inquiries is family violence and gambling. And as you know, gambling has been included in the DSM as a mental illness. Well, what would you want in a submission for gambling as a mental illness for a special circumstances application?
Okay, yeah, so we have received some applications for gambling. Typically those applications have come through the exceptional circumstances branch of the court, so the person is saying that that was an exceptional circumstance in their life at the time and that caused them to conduct the offence. In terms of special circumstances, the nexus would be quite a difficult challenge for that person. They'd need to be able to demonstrate how the gambling had led to them failing to control their conduct. So essentially it would fall under the same standard criteria. So we'd be making an assessment based on that.
So the legislation requires only that sufficient grounds are shown. That's obviously interpreted in practice as special circumstances, but are there different streams within the infringements?
Yeah, within the court we have a team that specifically work on special circumstances applications, and they're responsible for getting through those. It's a far smaller cohort in terms of the number of applications and the number of registrars, and then there's a broader team that works on revocations, and they're sort of split into exceptional circumstances, nominations, and then they also deal with some cost variation applications.
Family violence is presenting in two forms as our practice in regard to special circumstances. The first aspect is where the client did not commit the offence and is unable to nominate another driver because that could result in further violence against them. The second aspect is where, because of the violence perpetrated against them, that they have incurred infringements. So, do we treat these as two separate issues? As you know, we are making these applications under exceptional circumstances rather than special circumstances, and there are no guidelines specifically for these. So how do we get an effective outcome for our clients in both of those types of scenarios?
Well, from a policy perspective, we recognise that family violence is a significant issue and it isn't dealt with currently as a separate discrete issue under the special circumstances definition. We are awaiting the outcomes of the Royal Commission into Family Violence to see what those recommendations are before we review our definitions of special circumstances and exceptional circumstances, because we would hate to preempt the outcome of the Royal Commission and do anything that would be contradictory to or in contrast to their recommendations. It is on our agenda. It is something that's very important to us, and we recognise that it's an important issue to be addressed. And I'd also probably just add another issue about the definitions of special circumstances and exceptional circumstances are ripe for review. We get lots of feedback from our stakeholders, not just on the family violence issue, but on homelessness or on the nexus. So there are a range of issues that could be considered as a more wholesale review of both of the definitions. From a pure policy perspective, it's appropriate that all of that is done at the same time. They are key working definitions in our legislation, and to make changes continually would disrupt and maybe be inequitable to people who are constantly within the system. So we want to minimise the changes and do them at one time, and so we can prepare for the changes for people who are travelling through the system at any given point in time. So that's probably what I'd say from a policy perspective.
Okay, so that's the policy position. From an operational perspective, we're receiving these applications now, so we don't really have time to wait for the outcome of the Royal Commission or for any of those sort of broader changes. In terms of those applications, we typically see them as nominations and that they're received sort of out of time. So what will happen is a person will write in and say, I wasn't able to nominate at the particular time because there were concerns for my health and safety if I were to do that. Or alternatively, the person will write in and they will say, I did commit these offences. The infringements never got to me. I never had access to any of my mail. I'd like to pay them off. I'd like to go into a payment arrangement, a payment order. When they submit those payment orders, typically what we will do is remove the cost. So we'll take any warrant fees that are associated and we'll take any enforcement order fees. So those people are just paying the initial infringement cost as part of their payment order. When we do receive them through special circumstances, we have actually had some applications where people have been able to mount an argument to say, this person didn't have safe refuge at the time, therefore they're complying with your homelessness definition, and they've been able to put specials through that way as well.
I would say that there are increasing numbers of people coming through the system where family violence has been the main issue, and people are coming forward more and seeking those to be resolved, and at this point, for people to have that uncertainty around applying under exceptional circumstances is extremely stressful because it's not defined. We're not sure what the outcome would be, and to sit with that uncertainty and not know what's going to happen is extremely stressful for women who are escaping really dangerous situations, and even to be able to nominate later is not safe for people to do. I really look forward to the changes in the policy and see what might come from that to improve these people's outcomes.
It's definitely a priority.
Can I perhaps say one further thing, Gary, because we've spent a bit of time at the edges of the Infringements Act talking about a 10-month delay to be registered earlier, and now talking about the edges of exceptional circumstances. 99% of the time we're talking about mental health issues and the connections, where the debate is. Can I perhaps ask Angela, if I may? We see a number of people with depression and anxiety as their diagnosis. A number, I reckon half of our clients. And it can be, I think, difficult for practitioners to draw a connection between that and toll offending, for example. Is it something that you're perhaps growing weary of?
Depression and anxiety is certainly a term that's referred to quite often, but it is, again, the nexus. And is it a sort of a chicken and the egg? I mean, do they become anxious and depressed because of the number of infringements that they're having to deal with? Or is it because of their anxiety and depression that has led them to incur the infringements in the first place? Oftentimes it's a result of their becoming aware of, oh my goodness, these are all the infringements I now have to deal with. They become anxious and depressed because of the end result. And it's difficult. It's difficult because that is the term that is referred to the most often, depression and anxiety. And that's not only in the special circumstances list. I can tell you that's within the most plea material that you will get before you in any other matters is depression and anxiety. And it's not to say that I don't believe that these people are actually suffering from depression and anxiety, but in the special circumstances list, I need to be satisfied that it's because of the depression and anxiety that the offending continued or was caused, rather than them having to deal with the repercussions of their actions.
When we're writing to practitioners, I guess we just need to really keep that in mind. If that's the only diagnosis we have, we need to be putting it back on them to convince our honour that that is so.
It has to be linked to the behaviour.
Under the reforms that are proposed, I believe that there's going to be some changes with a new test, terminology, and an opt-in option in special circumstances. Would you like to outline some of those changes that are in the pipeline?
I'll take the opportunity to talk about three main changes. So there are some small changes to the internal review process, which we think will be very useful, just to add an additional ground for internal review, so council not aware. So if someone is genuinely unaware that they've been issued an infringement notice, they can apply under the internal review mechanisms within 14 days of becoming aware. So I think that adds some clarity to the process for somebody who is genuinely unaware. And one other key change to the internal review process is that the automatic referral to the court has been removed where a special circumstances application has been refused. So currently there's an automatic referral to court. That will be removed, but we clearly stated within the legislation what the applicant has the opportunity to do, and their options will be to elect to go to court if they want to, or to pay, or to go into a payment arrangement, or to apply for a work and development permit.
Susan, you've jumped ahead of me.
Yep.
Internal review is the next section we're going to talk about.
Sorry.
What I
Enforcement
would
review?
ask is, with the special circumstances revocation, what changes are going to happen in that area?
So the whole revocations process is going, and it's being replaced by a process called enforcement review. It is actually timely that I talked about internal review first, because enforcement review will mirror internal review. So the whole rationale behind that is that we'll have consistency in decision-making, consistency in processes. People will be able to understand what rights they have, what applications they can make, and they should be getting to consistent outcomes. So the enforcement review process will be available under the Fines Victoria model, and a person can apply under the same grounds as for internal review, including counsel not aware. And under enforcement review, if the Director Fines Victoria cancels the enforcement order on the basis of special circumstances, the automatic referral to the court will be removed as well. So that takes one loop out of the way, and then the enforcement agency would have 28 days to opt in to go to court, and so they have to make an active prosecutorial decision, and if they don't make that decision within the 28 days, then they need to take action, including withdrawing the infringement notice or withdrawing and issuing an official warning.
That's quite a significant change, and do you envisage that this change will remove people with special circumstances from the criminal justice system?
We anticipate that unnecessary matters going to the court will be reduced, because enforcement agencies do have to take an active prosecutorial decision. So by being inactive currently, matters will be referred to court, but now that they will have to go through a process for those matters to go to court.
Sam, you'd be aware that the Victoria Police very rarely withdraw matters from an operational point of view. Do you envisage that they might change under this new system?
I'll have to echo Susan. I wouldn't want to preempt what Victoria Police may or may not do. However, what I would say more broadly is that because the option now, it's sort of an opt-out model, so it defaults to court. When they're compelled to opt in, I suspect that we'll see some changes in behaviours. I'm just not sure which agencies it might affect more so than others.
Internal review is where the infringement is still at agency stage, and you can write to that agency with the same circumstances, special circumstances, exceptional circumstances, revocation circumstances, to have that matter withdrawn. Joe, one of the problems we've had with internal review is inconsistency.
There are many agencies that issue infringements in Victoria, and there are few that would actually grant that internal review and get a good outcome for the client at this stage. There are 3 local councils in my area that I feel reasonably confident saying to clients that an internal review would be a reasonable path for a good outcome. But even when I've had matters of drunk in a public place for a person with special circumstances for alcohol abuse, they applied for an internal review themselves with good documentation, was turned down by the police and ended up as an open court matter. Even where the link looks really clear, clients are still ending up with matters in the open court and having a bit of a roulette situation where they don't know who they're going to be in front of and what sort of outcome they're going to get from that. Whereas if they waited and extra costs were added as the infringement moved through the system and made an application for revocation with the infringement court, they would probably have a much better outcome. But the client has to sit with that discomfort of the infringement moving through the system and the extra costs being added. And it's quite counterintuitive to be saying to clients, look, the longer you wait, the costs will be added on, but you'll probably have a better outcome. They see it as being quite logical that they get in early and deal with things early, but the system is not working like that.
I think that, as Joe said, I mean, that's the main problem, and it's been recognised by Justice and Regulation, and it's part of the reforms is to try and fix this problem that internal review, if you apply on the basis of special circumstances which are refused, then it automatically goes to open court, so not the special circs list, and you could end up anywhere. And as a matter of practice, most applications for internal review are refused. I can't really say, Gary, who applies good policies these days, because it's my policy not to use internal review. It's too uncertain. I tend to wait for matters, if I'm satisfied the client has special circs, to get through to the infringements court stage and then seek revocation. I've heard from other people that I know some councils are a bit more forward-thinking, and there was a UN Global Cities committee a few years back that came up with some great policies that particularly Melbourne City Council, Yarra City Council adopted, and have great policies now on internal reviews. But when you're dealing with, commonly our clients have 20 to a couple of hundred fines, you're not going to go through them all and identify which ones should be internally reviewed. You just wait for them all to hit the infringements court and use that time to get your reports and seek revocation.
So would you make multiple applications for special circumstances where you see those matters with, say, the police moving through the system, but you already have a number of matters that are at enforcement? Would you make more than one application? Yes, well, this is what we alluded to earlier. You have to, and there's a diagram I think we'll stick up overhead later on that shows the life cycle of the fine. We're probably all familiar with it, but it starts at infringement notice and ends at warrant. When your client comes to you, they might have equal numbers or sporadic numbers, but they're going to have fines across that whole system. The warrants are active warrants, so you need to do something about those, or the warrants will be executed, they'll be arrested and bailed to attend, and we'll talk about open court, we'll talk about this later on. So you have to do something about the warrants, so you have to seek revocation if your client has special circs, but that doesn't deal with the first two stages of the fine. So that might take a few months to cycle through to the special circs list because it gets referred to the issuing agency. They don't withdraw it, it goes onto the special circs list, and that takes a few months. In that time, the fines from stages 1 and 2 will make their way to the infringements court. In that time, your counsel to your client would have been accepted and they will have stopped offending, so that will hopefully be the end of the infringements. And then you'll have to make another application and that will clear them all out. Of course, our clients are, some of the most difficult, have the most entrenched problems, and despite our best advice, sometimes can't avoid their chaotic lives, symptoms of their illness, whatever it is, and so they do continue offending, albeit generally at a lesser rate, and so sometimes you have to make a few applications. And I'm sure Angela can speak to the number of times that we're trying to have matters consolidated and heard together, and there's another tranche coming through, and so we often have files open for a couple of years, unfortunately, to try and clear them out just for one client.
It's very important feedback that we receive about how our stakeholders perceive the internal review process and questions of consistency across enforcement agencies. Under the Fines Reform Act, there is a new internal review oversight power that will be vested in the Director Fines Victoria, and under that power we'll be issuing guidelines in relation to conducting internal reviews. The Director Fines Victoria will also be able to request information from enforcement agencies about how they're conducting their internal reviews, and the Director Fines Victoria will be able to report to the Attorney General general on system-wide issues or particular issues of concern. So we're hoping that new oversight power will be a really useful tool in helping bring enforcement agencies together, to educate them on the legislation and to provide a more consistent approach to internal reviews. And then that taken in regard to, also in conjunction with the enforcement review process, which we think should mirror each other. Hopefully the decisions coming out of Fines Victoria will also be a model for enforcement agencies when doing internal review. So we hope the process will become a lot more consistent.
Great.
Thank you. Consolidation. Damien, would you like to explain?
Sorry, Gary. I guess I didn't speak of one of the issues of internal review as well. So if the application's refused for internal review, the matter will be listed in Open Magistrates Court anywhere in Victoria, and it will be closest to the issuing agency. So if people have council fines from all over Melbourne, then you apply for internal review and it's refused, you'll end up with hearings at multiple venues. And you can have those all consolidated, but that's a bit of work with liaising with the courts and so on. So I guess that's just a practical reason against internal review, as opposed to revocation, where they'll go to the special circs list and the client only has to take the day off work once. I should have added, Gary, once they're in open court, they can't be adjourned into the special circumstances list. So if you've got multiple matters in the special circs list, you can have them heard together. But if you've applied for some internal review and some revocation, some are in open court, you can no longer ever get them back into the special circs list.
It's very rare for them to be dealt with in the specials list because the difficulty, and it's also to deal with, it also has to do with the prosecutors. They're different prosecutors. Even the police, they have different prosecutors that deal with open court matters as opposed to special circumstances matters. And Damien is absolutely right. You'll have people who are listed in Broadmeadows in open court, or Sunshine in open court, or Mildura or Geelong or anywhere in Victoria in open court matters. To have them consolidated to the special circumstances is logistically very difficult, and it's very rare that happens.
I don't have the Act in front of me, Gary, but I think the effect of it is it takes you out of the infringement system and the underlying charges then, so you're into the criminal justice system, referred to open court and dealt with that way.
I have had some success with particularly Department of Transport, where there's been transport infringements being heard, say, in Ringwood or one of those other courts, and we already have a hearing in special circumstances. They've been helpful in bringing the matters into special. I
suppose the Department of Transport matters, what works for them is that their day at Melbourne Magistrates Court, their open court matters, is a Thursday, which is a special circumstances day. So it may not be, and one's in court 18 and one's in court 17, so logistically they don't have those sorts of problems. So, and if the prosecutors are happy for it to be dealt with on the one hearing, that's not an issue. But I can't remember the last time I've had a Department of Transport from another suburban court
Probably
listed
me.
in a special. Yeah, so. But that's one of the benefits of the Department of Transport. It's on the same day in adjacent courts.
Would you like to just say a little bit more about the oversight process for internal review and how that might change under the reforms?
The oversight process is a new process under the reforms, so the policy and business processes underlying that are currently being worked through. No final decisions have been made on the exact mechanics of it, but basically under the legislation, the powers will be to oversight the internal review process, provide guidelines, issue guidelines which will help enforcement agencies develop their own guidelines. It's an information requesting power from the Director of Fines Victoria and the ability to report to the Attorney General. So that's the basic machinery in the legislation, and we're just working out the underlying policy now.
So the next section, revocation from the infringement court, will deal with what happens if our application isn't successful, what other options our client has, for instance, payment orders, and the big new reform that's coming in the reform is the work and development permit.
Well, as a policy officer, work and development permits are the shining light of fines reform. It's a very exciting initiative. I think it provides a very good avenue of assistance for our vulnerable cohorts of people that might be suffering from a range of conditions or circumstances and who have infringement fines. So the work and development permit scheme is basically a scheme whereby a person with infringement fines can speak with their accredited health practitioner or community sector organisation and come up with a voluntary plan to undertake treatment, training, counselling, and if they're under 25, they can do mentoring, they can do unpaid work, and they can do this to pay off their infringement fines. Basically, a work and development permit will be available to somebody who has a mental illness, disorder, condition or disease, someone who has an addiction, who's experiencing homelessness or has acute financial hardship. So it's a little bit different to how internal review or enforcement review will operate, and it's a broader category. So you don't have to prove a nexus, you don't have to prove that your circumstances caused the offending or resulted in you not understanding the offence. It's more you're actually just saying, I have these infringement fines, but because of my circumstances, I'm finding it difficult to pay. So in one way, you can think about it like a non-financial payment plan. It's an exciting option because of the range of activities that you can voluntarily agree to undertake with your community sector organisation is quite broad, and those activities should be tailored to your specific needs and hopefully with the aim of rehabilitation or to help you get back up on your feet. It's voluntary, so you get to choose what you're doing and you get to choose who you're doing it with. What makes it a little bit unusual is that a community sector organisation will need to become an accredited sponsor with Fines Victoria, so they need to go through a separate process to be accredited with Fines Victoria, to be able to submit your application, to supervise the activities that you're undertaking and ensure that the WDP is on track. So the community sector organisation or the health practitioner, whoever it may be that becomes accredited, will need to report to Fines Victoria on the activities that are being undertaken in a particular WDP, provide information to the Director of Fines Victoria where necessary, and just monitor that person. So it's a really interesting and exciting new scheme for us, and we think it will help a lot of people who might not traditionally fall in the internal review process.
So if an organisation like Lentara Uniting Care in Broadmeadows was a sponsor, would it only be activities they do with Lentara, or if the client is getting treatment from a number of different services, can they be included as well?
Yes, yeah. So we recognise that a particular organisation mightn't be able to provide all the services that a client would need, as long as that sponsor can monitor and be in some contact with the referred providers, and the referred providers provide relevant activities under the scheme, that can happen. So you could have somebody working with Uniting Care for one aspect of their care and then going to a health service provider or going to training elsewhere. As part of the whole package of reforms, there will be an IT system that's being developed that will assist community sector organisations or any accredited sponsor contacting us, reporting in. We'll make it as easy as possible. There will be a lot of support and information and guidance when the scheme is being rolled out as well.
What if an agency is a sponsor but then they stop engaging with that client? What happens, but the client is still having treatment elsewhere? What happens then?
A WDP can be cancelled in a variety of ways. The Director of Fines Victoria can cancel a WDP. The client itself or the community sector organisation can cancel a WDP. So any of those parties could cancel a WDP for a reason, but that client may still need care, so the sponsor would be transferred, and there are processes being mapped out to do that. It's at the beginning of the infringement's life cycle as well, so it's a proactive approach for getting vulnerable people out of the system as quickly as possible and giving them options to work off their fines.
At what stages will someone be able to apply for a WDP?
From the moment an infringement notice is issued. Currently the Fines Reform Act enables somebody to apply for a WDP at any time up until registration with Fines Victoria. From the moment WDPs has been put out there into the universe, we've received consistent stakeholder feedback that please expand this scheme post-registration Fines Victoria. And from a policy perspective, we totally understand why it should be extended past registration with Fines Victoria. As you understand, with any legislation, to expand the scheme, it will require legislative change. So these are processes that require senior government approval and ultimately parliamentary approval. Legislative process. I can't preempt the outcome of that, but we have certainly briefed up about expansion of the scheme.
Sam, you've received an application for special circumstances and you're not happy with the documentation provided. So how do you react to that?
Typically when we receive an application and we're not satisfied with the material, the first thing that we will do is place a hold on any enforcement activity. So we'll say we've received an application, there's a stay, no enforcement activity is going to occur until we resolve this application. The next thing we do is write to the individual, so that's either going to be the person's representative or the individual themselves, and say, these are the reasons that we're not satisfied with your application at the moment. As I've said earlier, typically that's going to be around the nexus. It could also relate to the time frame of offending, so they might provide us with a medical report that postdates the offending or that says they suffered the condition up to a particular point in time, and we'll then send that out and provide the applicant 90 days to respond. Previously, we had sort of shorter timeframes, but what we were finding was that with this particular group of people that they weren't able to get out to either their legal representative or to their GP or whomever in that time frame, so we've extended that to 90 days.
So we see a lot of clients in urgent circumstances, many of whom don't contact us until the sheriff contacts them with a 7-day notice. So we're on limited time trying to get an application into the infringements court, and we don't have all the necessary material that we'll ultimately have. You mentioned then that once an application's received, a stay is put on any enforcement, so warrants can't be executed. What needs to be contained in an application for that to occur? Can you simply assert that you have special circs with more material to follow very quickly, or do you require something from a practitioner at that stage?
That's a very challenging question. Ordinarily, I would say the more information you can provide at the earliest stage possible, the better. In some situations, we have been able to stay applications or stay enforcement orders and warrants on the receipt of a document stating that an application was going to follow shortly after, but it sort of puts us in a very difficult position. But typically, I'd say provide as much information as early as possible.
Because it's stayed while pending your decision, isn't it? So there's a distinction between an application being received and being processed. Mm-hmm. What you're saying is we can put an application to try and stay the clock, to stop the clock, but best to provide something from practitioners if we've got it, and very
Absolutely.
quickly thereafter.
Yeah.
And the more and better material that you provide to the infringements court at the application stage shortens the process at the other end. So if the court has sort of detailed material that's been provided to the infringements court, you may find that the matter is dealt with on the one hearing. Oftentimes it might be enough just to get the revocation, but not quite enough to establish special circumstances at a hearing. So if you provide that detailed report to the infringements court at the beginning of the process, you may find that the end of the process comes a lot more quickly.
I mean, some of our clients, during their illness, might make applications not really understanding the criteria for an application for revocation. And so when they come to a financial counsellor or a community solicitor, they've already had one or maybe two applications for special circumstances which have been refused. What are our options in that case?
So you can only make two applications in respect of the one fine, one enforcement order, or one warrant. Any more than two applications requires leave of the magistrate's court. So you've got a couple of options there. If your client's already exhausted the applications, or you yourself have with substandard reports, and you've had two refusals over the same fine, you can either accept the refusal and allow it to go to a Section 160 hearing, penalty enforcement warrant hearing that we'll talk about after the morning tea, or you can challenge that decision, challenge the refusal by the infringements court by having the matter referred to the infringements court and essentially alleging that the infringements court got it wrong on the legislation before them, that there was sufficient grounds for revocation. Or the third option is you can seek leave from a magistrate to go back to the infringements court to make a third application. In our experience, if we think that we can get into the special circs list through the infringements court, we will still try and do that, so we won't go to 160 unless we are resigned to that. So the question for us is largely, do we seek leave or do we challenge the decision? These days, we're more inclined, I think, to seek leave to make a third application, particularly in this circumstance where a client's made an application on their own without the assistance of a lawyer, using material that isn't quite satisfactory. It's been our experience that magistrates have accepted that as a reason to grant leave and avail yourself of the infringements court properly with proper assistance. So I'd recommend doing that if that's a scenario that your clients come to you after having exhausted their applications. When we have challenged the refusal and said to a magistrate the infringements court's got it wrong, so the material we filed or we said was the circs already existed and revocation should have been granted, you can have mixed responses. You don't know really which magistrate you'll be before, you don't know what their experience with the infringements court is, and you're essentially alleging that the infringements court got it wrong in a busy magistrates court. Sometimes it can be hard for them to get their head around it. So that would be the probably non-preferred option, I think, at the moment.
So that brings me to applications for payment orders and variation of costs. So sometimes when we make an application for special circumstances, there are infringements that were incurred at the same time that don't meet the criteria for special circumstances. For example, speeding more than 25 kilometres over the speed limit. Sometimes our clients might, the option available to our clients is to pay those fines, and because of their special circumstances, we might want to make an application for a variation of costs under those same grounds. Sam, can you tell us how we would do that?
Yeah, absolutely. So if a person's wanting to apply for a payment order to pay their fines off by instalment, they'd simply submit that through to the infringements court in writing. There's a range of factors that we sort of consider when we're making that determination. So we're looking at things like whether the person has had any interaction with the sheriff, so if there's any active sanctions. We're also looking at things like whether the person's previously defaulted on payment orders, and their total indebtedness is another factor that we're taking into account. So where the person's got over $10,000 in debt, we don't ordinarily put those people into payment orders simply because of the amount of time it would take for them to resolve that payment order. If a person had successfully applied for special circumstances and for whatever reason presented a case to say that they wanted to apply for a payment order and also to have the costs varied, so to have the costs reduced, that there's a strong likelihood that we'd consider and potentially grant those. Also, where the person's on Centrelink, we're able to put them on an extended payment order, and we're able to do that through the Centre Pay function, so it comes out of their Centrelink prior to them actually receiving that each fortnight.
For some people who have more than $10,000 worth of fines and they don't want to go through the court process, having a payment order, an affordable payment order, is for their mental well-being, is possibly the best outcome for them. To have it refused and because there's more than $10,000 there, or because they've broken a previous arrangement, basically leaves those people in limbo, falling between the cracks and at risk of having sanctions applied by the sheriff. How do we help clients not fall between the cracks who don't meet those guidelines of payment orders?
Yeah, guidelines is a really important word because it's not prescriptive. We can look at the circumstances of these individuals and say, is it appropriate to put this person onto a payment order even though they sit outside that $10,000 threshold? Typically, we would say that it's important to look at what the best option is for the individual, and if you're saying that they don't want to engage in the revocation process, or they're not eligible for a special circumstances application, then their options are really limited.
What can we as practitioners do when we want to assist somebody to make a payment order like that?
Submitting a payment order in isolation, so just saying the person's financial circumstances, doesn't really give us grounds to grant it or to consider it outside of the standard guidelines. So any supporting material that you might have that mounts a compelling argument as to why we would put somebody on that payment order, it's really valuable for us because, as I said earlier, the registrars only have the papers before them. So in the absence of any additional sort of information, it's quite difficult.
Part of the reforms may be the idea of a debtor ID for people with outstanding matters, and this might be outstanding infringements and court fines, and they would be able to pay them on one payment plan. Can you give us a little bit more detail about that?
I possibly can't give much more detail than that, to be honest, but one of the main aims of the reforms is to have this central administrative body which is a one-stop shop for legal debt as such. So you can have your infringement fines and your court fines once they've been issued by the court, to eventually have them transferred over to the Director of Fines Victoria for enforcement and management. So that means, yes, you'd be able to go on the one payment order or payment arrangement, as it will be called. The detail of that, as you can imagine, it's a very complex reform, a very complex system operational reform, and I'm certainly not the best person to talk about that kind of thing, unfortunately. And more detail will come on that as it progresses.